Good evening. This is Rahul Reddy live here from Houston, Texas. Every Tuesday at 5 p.m., Reddy Neumann PC does bring in business immigration updates. Along with me is my business partner, Emily Neumann. Emily, now people are losing their jobs right now, and sometimes they don't have other employers to file, and they have to be in status within 60 days. What are the things they can do? One is B-2. Is there any other options that they can get employment authorization?
Yeah, we've talked about filing the change of status to B-2 because it's one of the easier applications. You can file it online. So if you're getting close to your 60-day period, it's relatively easy to get that filed. But those that have an approved I-140 may also have the opportunity to file the compelling circumstances EAD or the I-140 EAD. This one is also not a great option because it doesn't really give you status, right? I mean, what's the kind of
It doesn't give the status, the compelling circumstances where the people can obtain employment authorization, especially if they have an I-140 approval and if they are in the H-1, E-1 or L-1 visa. If their I-140 is approved, they would be eligible for the compelling circumstances EAD. It doesn't give them the status, but it is called period of authorized stay. So it will not be counted towards the unlawful stay while the EAD application is pending. So the circumstances under which that the compelling circumstances EAD could be applied is that if you lose a job and you want to apply for the EAD within 60 days, you have an I-140 approval already, you could apply if it's serious illnesses to you or to your family, or if there is a substantial harm to the employer, most probably this may not fit to you, or if there is a substantial harm to the applicant. Nowadays, since the travel ban is there, where people cannot travel outside the country, and they can't go outside the country, and they have to stay in the country because of the COVID circumstances, and they have to support their families. And all these people, especially the H1s and L1s, they are not eligible for the unemployment insurance, unemployment benefits that they get it. So they have to live in the country and pay in the country. So that should be a good attempt. If people want to, they should discuss with their lawyers to see if they are eligible for the compelling circumstances EAD. One more time I want to say, if you want to apply, you must have an I-140 approval. You must be in H-1B, L-1, E visa, or L-1, L-2 visa. These are the things where you absolutely need to have. And if you lose the job, within 60 days, you can file an EAD application. It may take 4 to 6 months to get an EAD, but in the meantime, you would be considered to have not been in unlawful presence.
So just to confirm, can they work while they're waiting for this EAD?
No, they cannot work while they're waiting for the EAD. Only after the EAD approval comes in, they can. The EAD can only be for 1 year period, and it can be extended again, but you need to prove the compelling circumstances one more time at the time when you file for the extension.
And then do you have the option of converting back to H-1B or L1?
No, it's called period of authorized stay. As you pointed out, it's not a legal status, Emily. So this will only allow them to get the EAD. However, though, if while they are on the EAD, if they get a job offer, some company can file the consular processing of the visas. So if it's an E visa or H-1B visa, the companies can file the consular processing. Most of these people, particularly the H-1 people, they're already counted towards the H-1B number. They already have I-140. So if in the interim period of this 1-2 year period, if they get a job offer, they can file a consular processing, and then once the H-1 approval comes in, then they can go outside the country and come back. In the case of the E3 visa, I mean, you don't need a E-visa, you don't need a H-1B approval from USCIS. Once they have a job offer from some company, they can go. So what this compelling circumstances EAD is that you are not associated with any particular employee. That's a great advantage, where the employees could file on there. So if you fall into any of these criteria, it may be worth for you to explore the option of the compelling circumstances EAD. But your I-94 must not have been expired to be eligible for this. Emily, now USCIS is telling that they may have a surcharge of 10%. Is it coming soon? What do you expect? Why is that surcharge? They were never working from home. They were always working from home. Why is that surcharge?
Yeah, I think it's ridiculous that they're trying to claim that this is due to the COVID-19 situation. In actuality, it's their policies that they've been putting into place for the last 3 years that are turning people away who would normally file something with them. They're making everything more difficult. People are choosing not to file, and now they're not getting that revenue, and they can't operate the agency without the revenue from the filing fees. They kind of shot themselves in the foot. Same with suspending premium processing. That was providing a huge amount of revenue to the agency, and ever since they suspended that, now they don't have this revenue, so now they're going to ask Congress to give them a bailout on top of increasing filing fees, yet still no guarantees of better service or improved processing times. So they kind of created their own problem here. I don't have much sympathy for them, but unfortunately, it's our clients that have to bear the brunt of
Simply
the
historically,
situation.
it has been proved that USCIS, when they increase the fees, the time goes backward. So this 10% surcharge, if they're planning, do you expect that once they take this money, better performance is going to come out, and the processing time for H4 and H4 EAD will come from 8 months to 2 months?
Definitely not now. I mean, you've got this added public benefit rule. So if you're filing your adjustment of status, you've got to file this 18-page 944 form, even for 2-year-old kids. Submit your credit report and your tax
Credit report for
transcripts.
2-year-old kid born in India?
Yes. And for all these things, that's just one example. Then you have the public benefit questions that are now on every I-539 application and every I-129 application. They're just adding all of these additional policies and procedures. They've added the green card interview back for employment-based categories.
Which
They've added the
didn't used to exist.
biometrics for the H4s. All these things they've added in that just make processing times worse. And then because people stop filing because of all these extra things, now they're crying to Congress saying, bail us out. It's not a very good business model.
I remember the Bush era, Emily. When Bush came into administration, he gave a timeline for 6 months to cut down all the timelines. And since the USCIS have not cut down the timelines though, he fired, one letter fired. All district directors are fired 6 months from now. He didn't fire them immediately. Because you didn't perform, I'm going to fire you from 6 months from now. Guess what happened at that time? The timelines that used to take 4 years, the timelines that used to take 4 months, came down to sometimes weeks, Emily. And sometimes we used to request to the USCIS officer, when the US citizen is married to somebody, please don't call them for interview within 2 months. We don't have enough documents for them to provide. Just at least take 6 months to adjudicate them in the green card applications. That was Bush administration. Now we have this administration that's completely the other way around, wanting to delay everything. This money is not going to do anything good. I hope the Congress will act something on this one to get some better plans. But this extra 10% is not going to reduce the time that they are going to work on. Emily, the USCIS has suspended the fingerprinting. USCIS has suspended the giving the green cards to the people now, because from 2017 onwards, everybody has to be interviewed. Previously, only family immigration used to be interviewed. Now everybody has to be interviewed. So this in-person thing, which they paused it from March onwards, when does it start? What do you expect after it starts?
So according to the USCIS, all of their in-person services, which are biometrics and interview appointments and naturalization oath ceremonies, they will be able to reopen those offices starting on June 4th if there aren't further extensions of the closure. So there's no guarantees in my mind that everything is going to reopen on June 4th. I would expect we'll see some additional announcements. Possibly some offices might be able to reopen, just depending on what's going on in individual states and cities. I mean, we've got different stay-at-home orders all across the country, depending on where you're at and what's going on with the COVID situation. But June 4th is the earliest we might see some of those offices reopen.
Emily, I've also seen the people have appointments right now in the U.S. consulates in Canada and Mexico starting the second week of June. However, though, I do warn the people, though, at this point of time, the instructions on the CBP website, or the USCIS Department of Homeland Security website, says that only the essential people would be allowed to travel from Canada to United States. Though you may be getting the visa stamping there, though, you may have a problem coming back into United States, though. I've heard stories that people were being turned down at the port of entry. They told them come back. I mean, they didn't deny their entry. They said just come back. Even though you may get the visa there, they may not let you in unless you are one of the essential worker. According to the definition, what they given that in the essential worker was the healthcare people, the food industry people, and there are some other exceptions that are available. These are the main things that I can point out. If you belong to any of those particular categories, I would like you to take all documentation that says. Now, this is only to Canada and Mexico, though. When you're coming from Europe or from Middle Eastern or Australia or something like that, the restrictions are more with regards to whether you have traveled to Italy and some other countries in the past 14 days. They haven't taken that restriction off until right now. So those are the restrictions that I see. But if you travel from Middle Eastern Airlines right now, the thing seems to be open. They can come into. I know people who, the flights have started back to India right now. Those are only for the Indian citizens at this point of time. With regards to the flights from outside the country to India, I've been told that people are now getting from India to here and some other countries to here too. They are being allowed. But the main restriction is coming from if you're entering from Mexico or Canada, definitely you need to check around before you take any of the decision. Emily, on the nurses, healthcare Workforce Resilient Act, and Senator Perdue from Republican Senator Perdue from Georgia, and Senator Durbin, who is a Democratic senator from Illinois. Now they sponsored this bill. When was this introduced, and what are the prospects? And if I'm a nurse, what should I do to get benefit in this one?
Yeah, so this was introduced around May 5th. And it is a bipartisan bill that has a lot of support that would basically provide a total of 40,000 green cards that have previously gone unused specifically for doctors and nurses. There's no requirement at this time that you have to work in COVID-19 or with COVID-19 patients. You have to go through the regular process of the green card, meaning that you need to have an approved I-140 or a pending I-140 so that when this bill comes in, if your priority date becomes current, you can file your adjustment of status based on that. So we've gotten a lot of questions recently from nurses, especially those that are in the H-4 EAD status right now, wanting to know, well, hey, can my employer sponsor me under this healthcare workforce Resilience Act? And yes, they can. Even though you're in H-4 with the EAD, you can still be sponsored. So the great thing with nurses is you're qualified for what's called the Schedule A green card. This means that you get to skip the first step, which is normally the labor certification. The Department of Labor has already stated there's a shortage of nurses across the country. Therefore, you don't have to go through the recruitment process and the labor certification process. So that cuts down about a year of the normal processing time. So your employer has to obtain a prevailing wage determination from the Labor Department, post a notice of filing, file an I-140 petition, and then as usual, if your priority date becomes current in your category under this act, if it eventually passes, then you can file the 485 based on that. In this act, those 40,000 green cards are not based on country of birth. They've taken off the 7% cap for that. So it should go to those that have the earliest priority date that are already filed and pending.
Emily, some of the quick questions that I want to go with people are asking, and I want to get to attention. Is there OPT ban from 23rd of this month?
Well, we know the Trump administration is famous for making announcements on the Friday before a holiday. So I would not be surprised to see an executive order that happens on Friday late in the afternoon or in the evening, because we've got a holiday weekend coming up. And it is around the time when he said he would talk about those additional measures that were in the last executive order. Can he ban OPT? I don't think so. I've gone through the regulations. There's nothing in the regulations or the statute that gives the president or anyone the authority to suspend the OPT program based on whatever happens to be going on in the country at a given time. He doesn't have the authority to do that. We already know they were planning on issuing new regulations, so yes, we could see some proposed regulations or some recommendations proposing new regulations to limit OPT, but it has to go through the regulatory process. So I don't think there's much concern that Friday automatically, poof, we don't get OPT anymore.
I'm more worried about rather than the executive order, because as you and we both agreed upon that it's very unlikely that it could be legally possible for him to ban OPT with the executive order. But there is no ban on it. He can do Twitter and say, hey, I'm going to do this and scare the people out. So at this point of time, I guys, if you're an OPT, be comfortable. You are fine where you are. Don't go into this scary tactics. And this administration is trying to scare you out. There is certain limitations. This is a law of a land. It's not just the president. There is also a Congress. There is a regulatory process. There is also a court system in this country. All these combined makes this country the greatest country in the world. Yes, out of all that puzzles, President falls definitely in a very influential thing, but it's not that the president can do whatever he wants to do. He can tweet whatever he wants to, but he has limitations with regards to what he can do on the immigration. Questions that are coming up on the H-1B lottery system. Will they conduct the lottery again? Very unlikely. One of the reasons is that when we look into the stats at our own office, we don't see many dropouts of the H-1B filings. That's number one. Number two, there's a report that just came out 2 days or 3 days before, which was published in Forbes. The unemployment rate in the IT sector has not gone up, while the unemployment rate in the other sector has gone 5 times. The IT sector has remained the same. It didn't change any significant at all. So most of the H-1Bs are getting filed in the IT sector. So we should be, the expectation that even if we were telling that there may be a chance, now we will downgrade it a little bit more. There's very less chance for second-time lottery on the H-1B.
Dang from YouTube wants to know, is it safer to go back to F1 in the situation of a job loss? And this is what a lot of people did during the last recession is if they lost their job in the H-1B, they would file a change of status to F1. It was a good option then, not a good option now. The reason for that is the processing time for the F1 is taking up to 10 months, and you have to continue to maintain your H-1 status while you're waiting. Since you're losing your job, you're going to be losing your H-1 status. It's not possible for you to continue maintaining your status all the way until you get that F1 approved. So this time around, it's not a good option.
Ramya is asking this question, how long it's going to take for the premium processing to restart. At this point of time, I think so that's not in the top agenda of the administration to restart the premium processing.
Rawi from YouTube has a good question, is with this possible executive order coming up, does he have the power to stop the H-1B filings or stop processing cases with USCIS for people that were just selected in the lottery? I don't think he has the power to do that either. His power is limited to suspending the entry of those that are outside the U.S. He does not have the power to tell USCIS you can't accept applications. He doesn't have the power to tell the Department of Labor to stop processing LCAs. I think that he can take suggestions from Department of Labor and from Department of Homeland Security about how they can better protect U.S. workers. But that does not give him the power to just tell USCIS to stop accepting applications.
Swapnil from Facebook has this question. He is working in Houston. Yay, Houston, our Houston. However, his work location is from Austin. Is there anything that he needs to do on LCA? Swapnil, you have to file, the company has to file a new LCA, and unfortunately they have to file an amendment for you to continue working in Houston. There is a limitation of 30 days, 60 days, depending on how you calculate it, but it's the company needs to file an amended H-1B. Sriram has this question from Facebook. What is the approval rating for specialty occupation RFE H-1B extension with an I-140 approval? Well, I-140 approval has nothing to do with H-1B extension. Those are two different items though. Specialty occupation RFE should be taken very seriously. Most of the denials that are coming are on the specialty occupation. At this point of time, to tell you that, and I don't like to say depends on, but it will be, what is your education? What is the position requirement? You may want to have a professor evaluate the position evaluation. Now, it's not just your education that is in line, it's the position evaluation that is also in line. Does the position qualify for the specialty occupation? Then comes the question whether you do have that or not. Those are the things that need to be there. Jaya Singh has this question from Facebook. She's a dentist. Will she be included in the nurses' healthcare bill? In the resilient bill that was being sponsored by Senator Perdue and Dick Durbin, it clearly mentions only two professions. One is physicians, one is dentists. Sorry, I take back. It's physicians and nurses. It does not list dentists in there. However, the HEROES Act, which has been proposed by the Democrats, but it's not a bipartisan. I do not give that much serious importance to that $3 trillion bill. I mean, that would cost $3 trillion. Out of the 2,000 pages bill that I went through it says that healthcare workers in general, it's loosely defined there. But it says that if they would work with a COVID patient, so it's a little bit confusing there. In that bill, there is a possibility for dentists, but definitely in the resilient bill that is sponsored by Senator Perdue, dentists are not included in it.
Vivek Anand from Facebook wants to know, is it easy to convert from B-2 back to H-1B again once we get a new job offer? Unfortunately, it's not. The processing time of the B-2 is so long that you'll likely have to leave the country before you ever get a response on it. If you happen to still be in the country while that change of status is pending and then you get a job offer, the new employer will most likely have to request consular processing of that H-1B because you're not in status at the time of filing. You're only in a period of authorized stay, which those are two different things. So once that gets approved, then you would have to exit the country, apply for the new visa stamp if you need it, and then come back in order to regain your H-1 status.
Anurag has this question. How long can he stay in the home? He's benched, he's getting paid. Anurag, I would recommend to work for your company rather than sit and do nothing at your location though. There is no limitation as long as you're getting paid, but I don't want you to just sit down and keep getting the money. Try to create something that is in the same lines of what your job description was before though. That would be the best way. And if possible, if you think so this is going to prolong for a long time, think of the alternate things. If you have a H-4 options, you may want to move into that one. Ramesh adds this question from Facebook. How long will the visa processing centers, how long will it take for the visa processing to be open? June 4th seems to be all likelihood that most of the offices, including the fingerprint office, including the USCIS personal interviews, and also the consulates are expected to open. As Emily was pointing out, you never know how the things are turning out. Based on the COVID situation, things can change. But as such, at this point of time, our information is June 4th.
Narendra from YouTube wants to know, how can I extend the H-4 EAD for my wife? It's expiring in August. I've already applied for the extension in March, but the application is not being processed due to COVID-19. She might lose her job. Unfortunately, we don't have any options at this point other than the usual expedite request process through USCIS. Because the biometrics aren't there, the litigation is not as successful right now, so we've put a pause on that. We don't have a good option for you, and USCIS doesn't seem to have any options either.
Devi has this question. Are the B-2 visa holders who are stuck in the country, are they automatically extended for a period of 6 months? The answer is no. You are not automatically extended for the period of 6 months. If the I-94 is expiring, you can file a B-2 extension online. It's called I-539. You can file online. Don't let it go, because if your I-94 expires, you stay here for one single day, your passport visa, which most people will have for a period of 10 years, is considered to be automatically cancelled. And when you try to come next time, and if the airline people did not notice it when you come into the country, they'll put you in jail for 2 years and send you back. So for that reason, for many reasons, please apply for the extension of the B-2 visa before your I-94 expires.
Venkatesh from YouTube wants to know, for a 6-year max out case, can we convert to a B1 if we're running out of time before the I-140 is approved, so we can remain in the country and then apply for the H-1 extension later? So you can convert to a B1, but you have to know that once you run out of H-1 time and you're waiting for the B-1 to be approved, you can't work. You cannot work during that situation. And again, because of the long processing times of the B-1 or the B-2, if you get your I-140 approved while you're waiting for it, you can't just file a change of status back to H-1B because you're not actually in B-1 or B-2 status yet. So your employer would have to request consular processing of the H-1B. You'd have to exit the country, obtain the new visa stamp, and then come back.
Emily, I want to inform you, this one question came from Selfmade from YouTube. Have you had any H-1B approvals which are cap subject H-1B in 2021? Today, I got the information. I had a consultation with a person today, and her H-1B has been approved. You have anything?
I don't have any yet.
Yeah, I got one approved. That's good news. That she filed in the first week of April or second week of April, and she got it approved yesterday. So I had a consultation with her.
Kieran from Facebook wants to know, how safe is it to transfer an H-1B to employer B when your H-1 extension with employer A is pending and you're in the 240-day period after your I-94 has expired? Well, I mean, you can do that, but know that when you do finally get your approval with employer B, it's most likely going to come without an I-94, putting you out of status. And the reason for that is because your I-94 is already expired at the time you're filing the transfer to B, employer A's petition is a bridge petition. It bridges the gap from the end of your I-94 to the filing of the transfer. Most likely that employer is going to withdraw once you leave the company, and that is going to cause the bridge to collapse. Or if that gets an RFE, or if that gets a denial, the bridge collapses, and that means your transfer also cannot be approved with an I-94. It'll be approved without the I-94. You have to exit, get the new visa stamp, and come back.
Abhishek has this question. He is about to get maxed out on L1A. Is it absolutely necessary for him to stay outside the country? And how is that 1 year calculated? Now, if you want to come back, Abhishek, on L visa again, if you maxed out, if you maxed out on your L visa, the L1A visa, you have to stay 1 year outside the country. And 1 year outside the country means that you must stay physically outside the country for 1 year. Any period of the time that you enter back into United States, some people do enter back on B1 visas to conduct some business that they have, which they can under the limited circumstances. So if, let's say, for example, you go outside the country, you stay there for 1 year, but in that 1 year period, any time that you visit the United States, even though you're not working, even though you're on a B1 visa, that period of time will not be counted towards the 1 year that you spent outside. Now, only visit to United States though. What if you were visiting Singapore, you're visiting for a business purposes, Japan or some other country other than USA? Now, that period that you visit Singapore or Japan will be counted towards the 1 year. The time period that you spend in USA will not be counted in there, but the time period you spend outside your home country other than USA will be counted towards the 1 year period.
Rohit from YouTube has his STEM OPT expiring on June 27th, and his H-1B is selected in the lottery. So he wants to know if he would get the cap gap until September 30th, and what happens if the H-1B gets denied in July, for example. Well, just being selected in the lottery is not enough to get the cap gap. Your employer has to actually file the H-1B petition on or before your STEM OPT expiration. So before June 27th, the H-1B petition must be filed with USCIS. It has to request a change of status, and it has to request an October 1st start date. Once that happens, then you are eligible for the automatic cap gap. You can go to your school and request an updated I-20, which will show your continued employment authorization till September 30th. However, if your H-1B petition gets denied in July, your cap gap authorization automatically ends on the date of the denial, and you begin your 60-day grace period unless the denial also includes a denial of the change of status due to a status violation of your F1.
Vishnuvardhan has this question. His wife is a physician, MD, working on H4 EAD, and she doesn't have an I-140. Will she be able to benefit from the bill? Now, based on the readings of both bills, though, at this point of time, she would not be able to benefit because she doesn't have an I-140 approval. What you could do, Vishwanath, is have your wife file an I-140 application right now. And once the I-140 has been filed, she would be eligible if the new bill goes through. Now, these are all the presumptions based on the readings of the current bill, which is not passed yet. There may be changes in the bill, there may be amendments. But based on it, if I were you, Vishnuvardhan, I would have her file an I-140 application, have her employer file an I-140 application. In that way, you'll be prepared. Now, what loss you're going to get it is that, yeah, the energy that you spend on I-140, if the bill doesn't go through, yeah, it may be wasted. But it's worth for you to have this I-140 approved. Now, many of the people ask this question, can a H4 EAD person apply for the I-140? Can they apply for the PERM application, H4 EAD persons? Don't they have to be an L1 or a H1 visa? No, they don't have to be. If you are on H4 EAD, you could file a PERM labor certification or I-140. You don't need to be on H1 or L1 to file for the green card application.
Vikas from Facebook has a question on the 7th year extension for H1. His PERM was filed 365 days before his 6-year limit will be reached, but his I-140 is still pending, and he wants to know if he can get a 7th year extension. Yes, so as long as your PERM was filed 365 days or more before you hit your 6-year limit, and the PERM is either pending or approved with an I-140 pending, your employer could request a 1-year extension right now, or they could wait and see if the I-140 gets approved in time and then request a 3-year extension as long as your H1 6-year limit hasn't been met yet. So you have the option of either one because your PERM was filed 365 days or more before your max out date.
Tripti has some update whether physical therapists are included in the GC expedite, and she has given the news. We don't have time right now at this point of time, Tripti. I know I chat with you on Facebook, so if you can give the link, give me some time to read it. At this point of time, there are many bills that have been introduced into the Congress to help the healthcare workers to get. The most likely bill that seems to be is the resilient bill. How do you spell it, Emily? Resilient bill, which was been sponsored by Senator Perdue and Dick Durbin from Illinois. In that bill, though, unfortunately, Tripti, you're a physical therapist, I know, the physical therapists are not included. Now, there are many other bills that are there that have included some of the other healthcare workers too, but in this particular bill, which is a bipartisan bill, I don't see that.
Krishna from Facebook is on H-1B and his wife has an H-4 with an EAD, and he wants to know if she can work for multiple employers. Can she set up an LLC, be a managed member? What options does she have? So as an H-4 EAD holder, she has an unrestricted EAD. That means she can work for anyone, she can work for multiple companies, she can start her own company. However, you as the H-1B holder are restricted. You can only work for the company that sponsored you. So you cannot work for the company that your wife sets up. You can be an investor, a passive investor, meaning you put your money into the company and you take the profits out, but you can't do any activities for the company.
Akshay has this question from Facebook. Is there a chance that the HR 1044, which has actually extra provisions for the nurses, which was which was introduced by Rand Paul, the first senator who got the COVID, I guess, he introduced nurses into the HR 10. I hope, Akshay, that the HR 1044 comes into picture. That will solve most of the problems, though. However, at this point of time, the Senate and Congress doesn't look to be that interested in putting that on the floor at this point of time. Question from Satya comes in from YouTube. Is it safe to travel to get the H-1B visa stamping under the current circumstances? I think so. Normally, safe means only immigration. So there are two aspects. One is it COVID safe to travel? Well, I am not a proper authorized person to answer that question, though. With regards to the immigration, though, I would like you to avoid it right now. With the unemployment rate being a little bit higher, we need to see when the consulates open what the trend of the consulates will be. So I don't want you to be the guinea pig, but if you are, let me know. But at this point of time, what we have noticed in 2009, when the recession was there, was that there was a good number of cases that got denied or got into 221G. I don't know at this point, pandemic situation, although the IT unemployment rate seems to be very low, we yet need to see how the consulates are going to react. They've been out of, they've been getting paid, but they are not doing their job for the past 2 months. When they come back, we don't know how they're going to act.
SPK from YouTube recently got his H-1B extension approved, but his dependent's H-4 approval is still pending, and he wants to know if there's any issue with their legal stay if it's not approved before the 240 days. So for H-4s, there is no 240-day rule. So as long as their extension was timely filed, they can continue to remain in the U.S. the entire time it's pending. So no issues there. As far as whether you can do a case inquiry with USCIS or not, you have to look at what the processing times are based on the service center where their case is pending. And if it's outside those processing times, then you can do an e-request online or call customer service.
Emily, I want to have some discussion on this executive order. And the people are panicked, and the media in the home country where I come from, I mean, they're bombarded. They're going to throw everybody out. They're going to do all those things. And we have dispelled all the fears when the executive order was actually issued. Before the executive order was issued, we predicted what the executive order was. And it turns out that actually it was more lenient than what we predicted a day before. Now there's a lot of fear among the people. I mean, they're telling, oh, H-1B will be banned, OPT will be banned, STEM extension, will that be, can that be banned? Will that be banned?
No, I don't think so. I don't think the president has the power to do any of those things. His power is restricted to suspending entry, and that's about it. That's the only thing Congress gave him the power to do.
And that too for a limited time, for a limited section of the people, not the cross-board of the people.
Exactly.
So please don't be panic mode. Even if you get any Twitter in the middle of the night, guys, don't panic. Come to us. We will address those things every Tuesday. If there is something which is like an absolute urgency that you need to know, we will have another live session just for that. So don't panic when the things come out. We will be there every Tuesday coming in. We know what you want. We understand you. We speak with you every day. We are the lawyers. We understand what you need much better. So please come to our every Tuesday. If there is something emergency that pops up, you can always log into immigrationgirl.com. Emily updates it immediately. If it's absolutely necessary for you, she updates it within. Most of the time, I just see the news and then here comes the Immigration Girl. So it's at immigrationgirl.com. You can go to the blog and we will update you. And if there is something, an emergency that's needed, we will conduct another live session at that point of time. But don't be panicked. We are already, you guys are already stressed up because of all the situation that is going on. Don't get stressed up with this executive order. We are not expecting anything spectacular in there. So do not expect much, anything that would bad occur immediately to you guys.
Yeah, I mean, my advice to people is just don't watch the news for a while. I've been telling so many people that.
It's very hard, Emily. I mean, it's Facebook, it's YouTube, it's like, it's there in the WhatsApp, it's there. People are calling each other up. The parents are calling because the news section in India is telling, oops, H-1B is going to be banned, OPT is banned, stomach extension. They're going to throw out the student visa. The parents are calling, the uncles are calling, aunts are calling. So it's hard. I mean, you can shut off the TV. What about the phone? Mom is calling. So yeah, so please watch our news, listen to your mom, but watch our news. I mean, we're not telling you not to speak with your mom, but we know on the immigration side what you need better than your mom. That's part we can tell.
Tejaswi from YouTube wants to know how many days an OPT student can stay without a job. So there are specified unemployment limits in the OPT regulations for both the initial 1-year period and the STEM extension. So for the initial 1-year period, you can have up to 90 days of unemployment time, and during the STEM extension, they extend that to 150 days, I believe. So you cannot exceed those limits. They're very strict.
Grusi Ram Bhatia from Facebook has this question. I-94 has expired because extension got denied. What are the better chances of getting the H4 or B2 approved? If between H4 and B2, I would always suggest H4 is a better option, no doubt in it. However, though, you need to consult a lawyer. Here is the reason, though. If you apply for the H4, by the time H4 has been decided, it's going to be more than 6 months. So what happens is that if your H4 gets denied, because you're filing under the thing called non-protunct, that means that please excuse me, my I-94 is expired, it's up to complete discretion of the officer. There are a lot of times we get denials of the change of status because of this argument. Now, this time may be different, but still, I don't want you to, because since the file of your unlawful, since the time of your extension got denied, all the way to the time that you get the H4 extension adjudicated, it will be counted unlawful unless the H4 is approved. Now, if you are unlawful for more than 180 days, you have a 3-year bar. If you're unlawful for more than 365 days, it is a 10-year bar. So if you wait for the H4 to be adjudicated, and if the H4 gets denied, you will be counted towards the 180 days, which is a 3-year bar. So you may want to file the H4 right now to try to comply with the law under the current circumstances, with no flights going to India. You don't know how to swim from New York to Bombay, according to my understanding. So you can apply for the H4, but when the things get better, you should plan to leave and you should consult a lawyer for this one.
Sanker from YouTube, his wife is on H4 EAD, and the EAD renewal is still not approved, and he wants to know if it's still pending when her EAD expires, can she continue working? Is there any kind of grace period for the H4 EAD? Unfortunately, there is not. If the new card does not come in and the old card expires, she has to stop working, and she's not eligible for unemployment during that gap period either.
Ankur has this question. His passport visa is expiring in November of 2024. I'm assuming that his I-94 is also expiring in November of 2021. That's one assumption, Mr. Arun Kumar from YouTube. I'm assuming that your I-94 is also expiring on November 2021. Please check that I-94 one more time for me. And his passport is expiring in July 2020. He cannot apply for the passport extension. Will it cause any problem for the status? It will not cause any problem whatsoever at all for your status if your passport expires and your I-94 is still valid. The Indian consulate people will extend your passport even if it's after July of 2020. I have had many of those situations where my clients have gone there. They did extend it as long as you have the valid I-94, which you said is valid until 2021 November.
Kamesh from YouTube wants to know if it's possible to have both an H-1B and an L-2. Well, you can only be in one status at any given time. So you might have an H-1B approval for consular processing and be an L-2 status, but that doesn't mean you're in both statuses or can use both at the same time. It's whatever you entered on, that is the status you're in, unless you've filed a change of status with USCIS. Once that change of status is approved, that's your new status. You can't keep the old status once your status has been changed or once you've entered in the new status.
Ritesh has this question. He did a lot of research on it. When would the Schedule A quota will be seen in the visa bulletin like the way that you see in May and June of 2006? Good question, Ritesh. Good research. Back in olden days, that he's speaking about is approximately 15 years ago, 16 years ago. The Congress passed a bill that allowed 50,000 green cards to the Schedule A people, which are physical therapists and registered nurses. In that Schedule A, the doctors are not included in it. Schedule A never includes doctors. It's only physical therapists and nurses. That 50,000 green cards was only available in those time, Ritesh. I have no accurate figure at what time it started, what time it ended. You've done a good research on it. I can't remember it. I remember it was in May of June 2000 because most of my wife's brothers, siblings, they all got the green card at that time because they're all physical therapists. So I remember that they're getting the green card. But right now, Schedule A is still there for you to get an I-140 approval. But there is no special Schedule A green cards. They should still fit into EB2 and EB3. Those are all the only things that they can fit, especially nurses and physical therapists. Now, there are also extraordinary ability that also are considered to be exempt from the labor certification. That's different. But Schedule A that is automatically certified are physical therapists and nurses. They can get the I-140 approval, but they still have to go through the same line what everybody else goes through, which is EB2 and EB3. There was a line before that only 50,000 were being given to them, and that does not, it's exhausted, that's not there. So what the Congress is trying to do is create the same kind of thing what they created back in olden days, in the time of Clinton era, where they did, 2006, no, it was actually Bush era, where they created the extra green cards. So let's hope that this administration also will come up, will create some extra green cards for the nurses. If it does, then we can see those things in the visa bulletin. Don't expect that in October, in the June visa bulletin of 2020, you can expect that Schedule A. Absolutely, it's not going to be there. Emily, another question that comes in is that why is the visa bulletin not coming out? It's 19th, I checked it, it didn't came out. I don't know if it came out in the past 1 hour I'm sitting here, but why is it? It was coming between 9th and 13th. Why is it?
I don't know. I think a lot of people have a conspiracy theory. When it didn't come out last month, they said it was because of the executive order, and I don't think it's any of that. I think it's just there's no requirement for them to put it out at any certain time. It was just convenience that they happened to do it earlier then. Different Department of State, they get to do things however they want. I don't read anything into it. I don't know about you.
No, I don't think so. You know, a lot of people are working from home, a lot of different calculations. So also they need information from the consulates which are closed, and they also need information from the USCIS. There was at one point of time, there was a complete breakdown between the USCIS communication with the State Department. That was in June of 2007. And they just said all the priority dates current, and then they went back and forth. It was a big drama that happened. The same confusion happened in September of 2015. So right now they're trying to play a little bit more cautiously, the State Department. But nothing, I don't think so there is any conspiracy theory for this.
Shiva from Facebook applied for an H-1 transfer, and the new employer asked him to start working on the receipt. Wants to know if there's anything that the current employer can do, such as revoking the H-1B. Yes, when you leave your current employer to join the new employer based on the receipt notice, your old employer has every right to withdraw your approved H-1B petition. That doesn't impact your transfer. You can still be working for the new employer the entire time, but it does put you in a risk. If that transfer were to be denied, you're immediately out of status. You don't have an old petition or an old employer to go back to at that point. So that's where the risk comes in.
Kamesh has this question, can L2 work without an EAD? No, you cannot. Sharath Singham has this question that the person is on H4 right now. H-1B got picked up, but he's also filing as a backup H4 extension this month. What happens if the H4 and H-1B get approved with some time gap? Means one approves in, Sharath, whichever is approved the latest. Latest means, for example, if the H4 extension is approved in November, and if H1 gets approved in December, then H1 is valid. And if the H1 gets approved in October, then in November H4 gets approved, then from October to November the person is on H1, and from November to afterwards it's the H4. But then also that comes up when the H1B gets approved before October. Okay, things are different. When the H4 gets approved before October and the H1 approves gets before October, it doesn't matter which one gets approved, what time, the H1 will prevail from October 1st, because it's not the last action rule. Not only that, because H1 doesn't get kicked in until October, because H1 application was only filed with the start date of October. It was not filed before. However, though, what I would suggest you at this point of time is get both the thing approved, okay? Don't get both the thing approved. When first one is approved, I would recommend that you contact a lawyer though, okay? You will not be in any danger, just contact the lawyer. The reason is that sometimes people can switch it back and forth. How can you switch it back and forth? It's taking years or it's taking months for the USCIS to get it. No, there is something called automatic revalidation. You can go to Mexico or you can go to Canada, you can re-enter back. So even if you say that you may be on H1 and you want to move back to H4, you can just go to Canada and you say, I'm happily married with this person, I'm coming back on H4. They will allow you, they'll give you H4, you're on H4. You can do the same thing the other way. You go outside the country, look, I have this H-1B approval, and you come in. You don't need a visa stamping, that's called automatic revalidation. But I would strongly recommend that you contact a lawyer when one of it is approved. At this point of time, I suggest you go ahead, file both the applications, that's good. But when one is approved, then I want you to contact a lawyer.
Deepu from YouTube wants to know what happens to an approved I-140 if the employee leaves the employer within 180 days after it's approved. Well, once you leave an employer, they have the option of withdrawing that approved I-140. So if you leave before 180 days and they withdraw before 180 days, you lose the opportunity to use that priority date, and you also lose the opportunity to use that for future H-4 EADs for your spouse. So it is a benefit to stay with that company for the 180 days so that if they withdraw after 180 days, you get to retain the priority date, you get to keep using it for H-1 extensions with any employer in the future, and your spouse can get the H-4 EAD extensions as well.
Self-made from YouTube has this question. That person's parents have 2 passports. One passport is only valid until June 15th. The other passport, 2020, the other passport is valid until a long period of time, I'm assuming. When they entered into the country, the passport, which has only on June 15th, got the validity of the B-2 visa. Can they still stay for a long period of time? That means the period of time that the I-94 expires, the stamping expires. Self-made, here's the thing. The I-94 controls, not the passport. In your statement, you did not tell me when the I-94 validity is expiring. But if the I-94 validity, let's say for example, is expiring in September of 2020, irrespective of where the passport where the stamping has been done, irrespective of where the validity period was been entered in the passport, it all depends on the I-94. If the I-94 says September, they can stay in September. If the I-94 says only June 15th, then they have to leave in June 15th, or under the current circumstances, they could be filing an extension to stay in this country.
Rachita from Facebook wants to know if there's a risk of being found to be a public charge during the green card processing if you claim unemployment while on H-4 EAD. No, there is not. The unemployment benefits are more like insurance. It's not considered to be a public benefit. So it doesn't count under that public charge rule. So you can use your unemployment benefits if you're in H-4 EAD and lose your job, and you are not going to be denied under the public charge rule for your green card.
A lot of questions on the H-4 EAD and L-2 EADs. L2 plus EAD can be filed at the same time. Same thing, H-4 plus EAD can be filed at the same time. A lot of questions on with regards to the litigation process. We have some setbacks in the court at this point of time, so we cannot file the litigation, and we don't have any expedited processing that we can advise other than contacting the Congress. If you subscribe to the RN Law Group news section, if there is any update on the expedited process that we have in the litigation, we will update you. At this point of time, we have suspended the litigation until the things are getting sorted out with the court system in a much better fashion.
Mudana from YouTube is working on OPT EAD, and the employer filed an H-1B, but wants to know, what if the H-1B has been approved, but then I lose my job? Will I be on F-1 or H-1? It really depends on the timing of the job loss. So if your H-1B is approved and it's after October 1st, the job loss puts you out of status. It does not put you back in F-1 status. If it's before October 1st, where your H-1B has not kicked in yet, your employer will need to withdraw your approved H-1B to allow you to continue on your F-1. That would be, and that should be done as early as possible, because that withdrawal process takes several weeks, and many times you need to go back to your DSO and ask for a data fix, because your SEVIS record probably was completed when your H-1B got approved, and they have to go back into that system and get that corrected to keep you in F-1 status. It's quite a hassle.
Vijay has this question: can unemployment benefits from L visa furloughed will affect the public charge? One thing is, Vijay, you are not eligible on L1A visa for unemployment benefits. What Emily was speaking was only H-4 EADs and L2s, not L1As. You are not supposed to apply. If you have applied, you need to backtrack it, you need to pay them money back, and you need to contact a CPA to take care of that.
Krish wants to know if there's any change in the H-1B grace period of 60 days in a layoff situation. No, there is not. There's a lot of false information out there claiming that you now have 240 days or all these different time periods. There's nothing that USCIS has relaxed for those that are suffering from job loss. The USCIS thinks their job is to protect U.S. workers only, so they're not going to do anything that they think is going to take jobs from U.S. workers. So if you're a non-immigrant in a work visa and you've been laid off, there are no relaxed rules for that. You have to continue to maintain status. You may need to look at filing a change of status to B-2, as we talked about at the beginning. If you have an approved I-140, you might be eligible for the I-140 EAD for compelling circumstances, but you do have to continue to maintain status. The 60-day grace period is not extended.
It's time, yeah.
I guess that's time. So thank you for joining us. If we were not able to get to your question, or you would like to speak with us in more detail about your specific situation, you can go to rnlawgroup.com and set up a consultation with either of us or any of our attorneys at Reddy Neumann. And please sign up for our newsletter, both at rnlawgroup.com and at Immigration Girl, so you get the latest updates as they happen without all the hype. We give you the practical information, which you really need to know, without trying to scare you.
We do have a 30% discount until May 31st if you book your appointment until May 31st. Imagine this, in 1 hour we cover almost more than 100 questions. If you have any of those things, you can make an appointment, and then you can please note down all the questions, submit all the documents and everything. You can do it online, and then we will speak with you. We can go over the entire policy, what your family thinks, what the situations, what your visa status, to update you on your particular necessity, on your particular needs, and address your needs more effectively rather than these short one-line answers that we are giving here. Thank you, guys.